So due to the late-breaking nature of some news, in the material for those of you who are present physically, there is a series of handouts. For those of you who are online, we will be posting these on our website after the session today, and you'll be able to link in to get these. Of particular use, if you're interested in following up on the details of the issues that Mark was just addressing, there is a post-Bostock checklist for 501c3 entities that's fairly specific in terms of the approach you might want to consider for looking at your own document package. The second rather breaking issue involves the sexual abuse claims by involving the Boy Scouts. I know that many churches over the years have sponsored Boy Scout troops, and unfortunately the national organization is now in the midst of a Chapter 7 bankruptcy filing. And this is potentially a serious problem for local churches due to the nature of this sponsorship agreement which many churches signed with the Boy Scouts. So if you happen to be a church that hosted a troop and you have any pending or potential claims against the troop that you sponsored, you absolutely need to take a serious look at the handouts in here. There are articles from both the Southern Baptist Convention as well as an update from one of the Methodist organizations with some suggestions for how to participate in the pending bankruptcy at the national level. We don't have time to go into it in detail, but I do want to highlight that to you as an important issue because the deadline for filing a proof of claim is November 16th. So if you have that situation, you definitely want to move that up your priority list. The other item that's in your handout here is a news account of a $22 million verdict for sex abuse that has been affirmed by a federal court. This was involving negligent selection by in this case it was a Jewish school, of the instructor. So the claim that could go against your church or your Christian school is for negligent selection and supervision and training. This involved a single child over a series of years, and the jury was absolutely inflamed and came back with a $22 million judgment. So this simply highlights what we've been saying for years. This sexual abuse situation is ongoing. It's serious. It's been further highlighted by what's gone on in the Boy Scouts. And many of the states are getting rid of their statute of limitations. So these claims can come at your organization from many years past. Finally, in your handout, there's a resource for vulnerable adults and churches with a list of adult protective services, child safety, child support, national suicide prevention resources, etc. So if you're not familiar with these, take a look at that information. So we'll take a quick look now at another recent Supreme Court event from this year. This one is a counterpoint to the cases which Mark examined. The cases which Mark examined dealt specifically with the rights of a religious organization to hire people who agree with their statement of faith. None of the laws of our country allow discrimination purely on the basis of sex, race, whatever. However, churches have a special exemption because they can hire or discriminate on the basis of those who believe as they do. And that's a very important distinction. So in the cases I'm about to highlight for you quickly here, the religious issue was not at play. None of these cases involved a claim that religious freedom had been interfered with. In Bostock versus Clayton County, a gay man began working for Clayton County, Georgia in their Welfare Services Division in 2003. There's a picture of Gerald, and I give you the pictures of these plaintiffs because I want to highlight the fact that these are real people involved in these cases. These are not just constitutional principles like you've heard me talk for years about the First Amendment, protecting our rights of religion and so forth. And that's not what we're dealing with in these cases. This is a guy who had worked for the county for years, decides he's going to play in a gay softball league, and is promptly fired. The next case that went with that is Altitude Express versus Zarda. The guy on top there is Mr. Zarda. He, a gay man, worked as a skydiving instructor for Altitude Express in New York. He was discharged a few days after he mentioned being gay, for no other reason than the fact that he was gay. Finally, the Harris Funeral Home versus EEOC involved a case where in 2007, the funeral home had hired a male funeral director. At the time, Mr. Stevens presented as a man. In 2013, Stevens sent a letter to the owner saying that he or she was transitioning from male to female. Amy's letter to the Harris Funeral Home said on August 26, 2013, "At the end of my vacation, I will return to work as my true self in an appropriate business attire." Well, Amy was fired because she did not dress as a man in a business suit. And that was the sole reason for her firing. There was no claim of a religious issue in the case. So what happened, the Supreme Court took these three cases together as a group, and in Bostock, the 11th Circuit had allowed the employer to terminate. However, two other circuits, the 6th and 2nd Circuit Courts of Appeal, ruled in favor of the employees. And when you have the Circuit Courts of Appeal reaching different conclusions on the same legal issue, that's a classic case for review by the United States Supreme Court, and that is in fact what happened. The Supreme Court took all three cases together as a single case. And the consolidated decision held that employment discrimination because of sex necessarily encompasses discrimination based on an individual's sexual orientation. An employer who fires an individual for merely being gay or transgender defies the law. Under Title VII, we do not purport, and this is an important footnote here, in this case was based on Title VII of the Civil Rights Act of 1964, which deals with employment issues. The majority decision said we are not purporting to address bathrooms, locker rooms, or anything else of the kind in this decision. They went out of their way to make clear that Hosanna Tabor and the Federal Religious Freedom Restoration Act still remain intact as important protections of religious liberty. In fact, they went on to say RFRA operates as a kind of super statute displaying the normal operation of other federal laws. It may supersede Title VII's commands in appropriate cases. But none of the employers in this case claimed that compliance infringed on their religious beliefs. So there was quite a bit of dissent about whether or not the majority had distorted the language of the original Civil Rights Act. We'll set those arguments aside because the law, it's good law for the moment. Over 100 federal statutes prohibit discrimination on the basis of sex, and that is the law for the present time. So there are several outstanding issues raised by this question, and we certainly are in an area of evolving jurisprudence. For example, will an employee who displays iconography associated with religion that opposes same-sex marriage be complicit in creating a hostile work environment? Can one expect that workplaces and schools will now enforce the use of gender-neutral pronouns? If someone misgenders another employee at the water cooler, will they be creating a hostile work environment for transgender employees? We don't have the answers to these questions, and frankly, the courts are wrestling with them. Will it be discriminatory to prohibit a transgender person from using a bathroom or locker room of their choice? Interestingly, the courts did not define what is a transgender person. So the bathroom and locker room issue is a subject of a lot of concern in many circles. That has not been resolved at this point. At least as long as the Trump administration's in place, they have issued guidance indicating that they the bathrooms are to be gender specific. In February of 2017, the Department of Justice under Jeff Sessions withdrew the government's appeal of an injunction in an earlier case. After the election, we don't know what's going to happen. So let's move on to a couple of other points here. Number one is, as you think about these issues, it's important to first consider, are you talking about a religious organization? A church, clearly, is a religious organization. A parachurch ministry, such as Teen Challenge, a food bank, a Christian school, those are considered parachurch ministries, and they most likely qualify to be able to discriminate on the basis of a statement, adherence to a statement of faith. But once you step away from the religious principles, there are no such protections. So I'll pause now. If there are any questions relating to that, we'll take those. If not, Jerry Steele, if you'd like to come up, we'll move on to the subject of removing disruptive people from our religious sessions.